हेलो एवरीवन, कैसे हो आप लोग? होप एवरीवन is safe and doing well. Today we are going to talk about Register of Members book and its case law. And आप ये देखोगे कि maintaining a book is not a mere formality, but it has its own importance. So the sequence would be: first I will quote the sections related to ROM, then we will see the case law, and then the final conclusion. So, let's start. Section 88, subsection 1 of Companies Act 2013 lays down, every company shall keep and maintain the following registers. A. Register of members indicating separately for each class of equity and preference shares held by each member residing in or outside India. B. Register of debenture holders, and C. Register of any other security holder. So, you might be thinking, what is Register of Members? The Register of Members or Register of Shareholders is a record of the individuals who hold the company and the details of the individual and the share they hold. ROM shall contain following particulars: name of the member, address, email address, permanent account number or CIN, unique identification number if any, father's, mother's or spouse name, occupation, status, nationality. In case the member is a minor, name of the guardian and date of birth of the member, the name and address of the nominee, date of becoming member, date of cessation, amount of guarantee if any other interest if any, and interest if any given by the member with regard to sending of the notice. Now, according to Section 95 of Companies Act 2013 provides that registers, their indices, and copies of annual returns maintained under Section 88 and 94 shall be prima facie evidence of any matter directed or authorized to be inserted therein by or under this Act. Now we are ready to see the case law.
Two friends meeting each other.
Hello Sarah, how are you?
I am good. What about you?
I am doing great. Please have a sit.
So, how's your investment in share market going on?
It's going well. Recently, I have applied 4,000 shares of 10 rupees each of Garland Petroleum Company and paid 8,000, but the company has not allotted me shares yet. Let's see, have not received any request of aliment till now. Leave that, you say, how's your investment in share market going on?
Garland. I have also purchased the shares of this company. Let me check the register of members tomorrow.
Oh, thank you, but I haven't been allotted the shares, so I think you won't find my name. Don't worry. I will deal with it.
Okay. Hello, how are you doing?
Great, thanks.
Ready. I wanted to ask you whether you have been allotted the shares of Garland.
No, why, what's the matter?
Actually, I checked the register of members book of Garland, and I surprisingly found your name.
Oh, okay, I will see. Thank you.
Mr. Reddy, after knowing it, took no steps for rectification of the register of members. Later, company went into liquidation and he was held liable as a contributory.
Mr. Reddy thus sued the company for removal of his name from the register of members. The court held that
when a person knows that his name is included in the register of shareholders and he stands by and allows his name to remain, he is holding out to the public that he is a shareholder, and thereby he loses his right to have his name removed.
Thus, we can say that a register of members is a prima facie evidence of the truth of its content. Accordingly, if a person's name, to his knowledge, is there in the register of members of a company, he shall be deemed to be a member, and onus lies on him to prove that he is not a member. He must promptly appeal to the tribunal for rectification of the register under Section 59 of the Act to take his name off the register, failing which the doctrine of holding out will apply. Holding out is merely an application of principle of estoppel, which is a rule of evidence, wherein a person is prevented or stopped from denying a statement he made or existence of fact that he makes another person believe. In simple language, it means that अगर आप ये fact deny नहीं करते हो कि आप उस कंपनी के शेयर होल्डर नहीं हो, तो ये मान लिया जाएगा कि आप उस कंपनी के शेयर होल्डर हो एंड उसके सारे कॉन्सिक्वेंसेस आप पे एप्लीकेबल हो जाएंगे. Like in this case, Mr. Reddy, after knowing that his name is in ROM, took no step to correct or rectify such misunderstanding. तो अब वो ये नहीं कह सकते कि वो कॉन्ट्रीब्यूटरी नहीं है और उन्हें बैलेंस अमाउंट ऑफ 32,000 रुपीस देना पड़ेगा. Hope you understood the case and the importance of ROM. However, be cautious and take effective steps if you find yourself in such situation. And I am sorry I could not find much facts about this case, so I end up making a fiction. Hence, if you think about writing this case law, I would suggest you to write only the facts of the case. Hope you enjoyed this case law. Have a nice day. Keep sharing with your friends so that I am motivated enough to make more case laws and make it more frequently. Thank you.